Senator Batters.
Thank you very much. Minister LeBlanc, prior to amendments made by your government to the Canada Elections Act in 2018 and Bill C-76, the word knowingly was in the Act. When Conservative MPs opposed removing the word knowingly and tried twice to reinsert this word into Bill C-76, your majority government blocked those efforts. Your government now claims that the word knowingly was removed as a housekeeping measure. In her judgment on this matter, Justice Davies said this in referring to advice given by a senior Privy Council office official, Mr. Jean-François Morin, to the House of Commons Procedure and House Affairs Committee during their clause-by-clause deliberations on those Conservative amendments to Bill C-76, quote, "More importantly, the advice given to the Standing Committee by Mr. Morin that the inclusion of the word knowingly in Section 91(1) was unnecessary, redundant, and confusing was for several reasons incorrect and potentially misleading, quote." And the judge went on to list all the reasons why. Minister, it is startling to see a judge so strongly criticize advice given by a senior departmental official to a parliamentary committee considering a bill. You were the president of the Queen's Privy Council for Canada when this case was argued in that court last fall and when this scathing judgment was rendered in February. What actions did you take in that department, if any, once you saw this judgment detailing the faulty advice your official gave to a parliamentary committee?
Well, Madam Chair, through you to Senator Batters, obviously senior public servants that are invited regularly to appear before committees of your chamber or in the House of Commons give to the best of their ability and knowledge the advice and the information that they have. We also respect that a judge in a court case before the particular court, in this case the Superior Court of Ontario, can hold a different view. We respect the court's finding, and that's why we, for example, did not appeal the decision but are seeking to correct. And as you noted, put the word knowledge back into the legislation. At the time, we believed, in good faith, obviously, at the time Bill C-76 was passed, that it would be a sort of a technical amendment clearing that up. The court had a different view. We are happy to respect the court's opinion and to act accordingly. Perhaps, I don't know if Al Sutherland or Manon would like to add something, but in our view, the advice tendered at the time was valid. The court had a different position, and we're proceeding to respond to the court's decision.
Minister, I think you've answered it very well. I have nothing to add.
I would just say, Minister, that this went beyond a difference of opinion or a different viewpoint, and it impacted the decision such that the judge said, after a careful consideration of the amendments in the context of that Canada Elections Act as a whole, I am left with only one plausible interpretation that Parliament intended the removal of the word knowing from 91(1) to reflect a substantive change to the prohibition and offence. So that type of advice, I just want to let you know, Minister, can have a dramatic impact, and that can even lead to a particular assumption by a judge on parliamentary intent. So I'm assuming from your answer that you didn't take any steps dealing with your department, but I just asked you to consider that. Thank you.
Thank you.